Today we are going to discuss criminal law, and in particular we will focus on general defenses. This is because usually general defenses arise in criminal law exams, and it's a very important topic for you to revise. It can apply it to any problem question. The discussion of general defenses is usually relevant to a lot of problem questions such as sexual offenses, property offenses, and so on. Before we move to the discussion of general defenses, I'd like to go through the general guidance that is relevant to all the law exams, and it is highly recommended that you follow this guidance when you're preparing for your exams. Firstly, you need to analyze your exam requirements. You need to know exactly what you're required to do and do a selective studying. In particular, for example, if you have a criminal law exam with a set of 6 questions, and you need to only answer 3 of them, probably it would be a good strategy if you only focus on 3 big topics that are most likely going to come up on the exam. How do you know what is going to come up on the exam? You go through the past exam papers. I cannot emphasize enough how important it is for law students to have a look at past exam papers, because usually the questions that you get on the exam are very similar to the ones from past year or the year before. So make sure that you look for them. It must be on university's website, or you can directly ask for it to the law school or to your professor. You should be able to get the past exam papers, and once you have them, you can identify the questions that usually get repeated every year and choose the topic that are most likely going to come up on the exams according to the frequency of how frequently it gets repeated every year. And then when you choose the topics that, 1, you are most likely going to come up on the exam, and 2, you feel more comfortable with, you can revise those topics. You can read your lectures on those topics as well as our resources, so you have all the relevant information you need to know about these topics. And after that, after revising, you need to practice answering problem and essay questions. Most of these students omit this stage, and it can be very bad for your grade if you only study the law and if you do not practice answering problem and essay questions. You are most likely going to get a very low grade. Make sure you practice. And for example, if you're in criminal law, if you revise property offenses, you need to first read the materials and then practice answering problem and essay questions in this topic. Usually property offenses come as a problem question, but have a look at your past exam papers if it has ever come as an essay question. If it has, make sure that you practice answering it. Finally, you need to follow your professor's guideline, because grading is subjective, and some professors have some specific requirements, specific recommended structure that they want students to follow, and you really need to make sure that you are aware of it. For example, I've seen a lot of students who were asked by the professors to start their problem questions in a certain way, to structure it in a certain way, to mention some specific set of cases in their answers. So make sure that you are aware of any such requirements, and also you need to focus on the cases that has been emphasized on the lectures. There are a lot of cases you could mention, but it is recommended that you mention the ones that are emphasized on by your professor. When you're answering questions, you need to follow the IREC structure. And I've seen a lot of students who do not support what they say with relevant legal authorities, which can be very bad for your mark. Whatever you say, it should be supported with a relevant legal authority. Has to be either a statute or a case if it's a problem question, and you need to reference it properly. If you do not reference, you're going to lose marks. Well, if it's a question, if it's an exam, maybe they are not. There's no requirement to reference scholar style, but there must be a requirement to reference at some level. Make sure that you follow the rules properly, because these are easy marks that you can gain if you follow the structure, the IREC structure, and if you always reference properly, even if your answer is not perfect, this will help you gain some marks. Conviction. What is a conviction in criminal law? Actus reus is a physical element of the crime. Mens rea is a mental element of the crime. Minus defenses equals to conviction. So a defendant can only be convicted when there is actus reus, when there is mens rea, and when there are no defenses. Therefore, in a problem question in criminal law, you need to always start with a discussion of actus reus and mens rea. Is there actus reus? Is there mens rea present? First, define what is the actus reus of the offence in question, and then define what is mens rea and apply it to the facts of the case. And finally, you always need to discuss if there are defenses. Like in contract law, you discuss remedies at the end. Here in criminal law, you need to discuss if there are any defenses that apply. There are some convictions, such as murder, for example, where there are partial defenses as well. But today, for the purposes of this class, we're going to only focus on full defenses. We also have cases where we're concerned with denials of offending, where defendant did not complete the actus reus or mens rea for several reasons. Remember, there only can be conviction when there are both actus reus and mens rea present and there are no defenses. So you need to go through the discussion in this structure. Is there actus reus? Is there mens rea? Are there any defenses with every single offense? If a defendant says, for example, I was not there, that means there is no actus reus. If defendant says it was an accident, that means there was no mens rea. I was drunk, I didn't know what I was doing, also no mens rea. I was covered in a swarm of bees and could not control my movements, no actus reus and no mens rea. This is just a formula for you to be able to understand in legal terms what this kind of statements could mean. Intoxication is the first defense we're going to discuss. There can be voluntary intoxication and there can be involuntary intoxication. Voluntary is when it's self-induced, somebody just gets drunk voluntarily without anyone forcing them to. And the other is involuntary, when somebody is drugging or giving alcohol to someone else without them knowing, without them making the choice. The difference between basic and specific intent crimes. For some defenses, you need to differentiate what is, if it's basic or specific intent crime. Basic intent crimes are the ones where the mens rea can be satisfied by recklessness, for example, assault, where specific intent is when there has to be a mens rea, a specific mens rea. For example, for murder, there has to be intention. Murder cannot be committed recklessly, it has to have an intention. The same with section 18 GBH, of course, the grievous bodily harm. That is also a specific intent crime because it requires specific intention to be for the conviction. DPP versus Majewski, defendant's crime was one of the basic intent, therefore defendant's intoxication could not be relied upon as a defense. So you need to make sure that the facts that you're concerned with in the problem question are either basic or specific intent, and then apply the relevant defense. There is also another defense that can apply, automatism. Automatism may be a defense if the defendant's conduct was involuntary, when the defendant was not able to control their bodily actions. It can be a defense to any crime, but it has to be a total loss of voluntary control. Insanity is also another defense, often claimed, when all individuals are, generally all the individuals are presumed to be sane, and the burden of proof is for the defendant proof, therefore on the defense to prove that the defendant was insane. Insanity can be used as a defense to any crime, with the only exception being strict liability offenses. Strict liability offenses can be offenses like road traffic accidents. This case is the main principle about insanity defense. Here, the court provided that to establish a defense of the grounds of insanity must be clearly proved that at the time of committing the act, the party accused was laboring under such a defect of reason from the disease of mind as not to know the nature and quality of the act he was doing, or as to know that what he was doing was wrong. This means that all these requirements we just named, the defect of reason, disease of the mind, they have to be discussed in turn and separately on the facts of the case. You need to apply them to the facts of the case and argue whether or not the defendant in the problem question scenario that you've been given had a defect of reason, whether or not he had disease of the mind, whether or not the defendant know the nature and quality of the act he was doing. Each of the requirements have to be assessed separately. Another full defense is duress. Duress can be by threat. When the defendant commits a crime due to threat by a person that he or someone else will be killed or seriously hurt. If, for example, a defendant is threatened that if he doesn't do a certain act, one of his family members could be killed. There is something like this kind of threat where the defendant is not really given a choice, he has to do it. Duress of circumstances can also be a defense. This is similar to the first duress by threat, but the defendant here is not threatened by a person, it's threatened by circumstances. Duress is a common law defense, therefore it's not, you have to discuss the relevant case law in order to be able to establish duress in a problem question. There is also the private self-defense in public defenses. Defendant has the defense to any crime involving force against the person or properly committed in order to protect legitimate interests. So if the person was self-defending, then it can be a full defense to a crime. Blake versus DPP. The defendant wrote with felt pen on a concrete pillar outside the House of Parliament in protest against the Iraq war. Defendant argued that he sought to avoid the first Iraq war and as a result relied on Section 3 of the Criminal Law Act 1967. The court held that the writing did not involve the use of force, therefore the defense could not be relied upon. Hence, there has to be, for this defense to be established, there has to be a use of force. If there is no force, this defense cannot be established. And you need to cite this case to argue that point, Blake versus DPP. As we said, with every argument you make, you need to cite the relevant authority. Also, there are some human rights implications like Article 2, European Convention of Human Rights, which allows for killing in self-defense, but only where it is reasonably necessary. So if it's a problem question where there's a self-defense issue, you need to discuss also Article 2 and have analysis about if the defendant used the force, the used force was reasonably necessary in the circumstances given in the problem question. Necessity is also another defense, but it's a very rarely used. This is known as the last resort defense. So if you're advising a party in a problem question, you should try to discuss the other defenses and only discuss necessity as the last resort, because you need to mention in the problem question that this is very hard to establish, this defense, and it only used on unique facts, only when there are no other defenses that could be used. The traditional view is expressed in Southwark London Borough versus Williams. Here, Lord Denning stated that if hunger were once allowed to be an excuse for stealing, it would open the door through which all kinds of lawlessness and disorder would pass. If homelessness were once admitted as a defense to trespass, no one's house could be safe. Necessity would open a door which no man could shut. Necessity can very easily become a mask for anarchy. In simple words, if necessity was easily establishable defense that could open doors to a lot of crime, like homeless person could say that I just needed a house to stay in. So it would be a defense to enter a house without permission, or that somebody who is hungry said that it was necessary for me to steal food, and it could open doors to stealing as well. So that is why necessity defense is very limited in application, and it can only be established in very particular exceptional facts of the case. You can read our full notes on this topic, which has an overview of all the main cases you need to know. At this link, you will receive the slides after this session. You are also recommended that you have a look at our model essays, because it's not enough to just read the law, to just know the law and the cases. It's really not enough. You need to know how to have a critical analysis in your answer. And the only way to practice with critical analysis, and the only way to really know how to do that, is to read our model essays, or if you have any example essays that your university has given you, that would be also a good way to practice with this. Case summaries is also a very important resource that we provide for you to read. Quizzes and flashcards are very important for students who have an exam soon and they are required to memorize a lot of information. It really helps you to focus on what is important and memorize the key cases and principles. So I highly recommend you to have a look at quizzes and flashcards. Tutorial videos are classes like this, as well as animated videos. So it helps you revise quickly with visual materials like this presentation and revision session. Now I'd like to give you a little bit of more information about how we can help. We are a team of content creators who are law students and graduates who have gotten recently very high grades. We've been in your shoes and we have achieved first class in 2-1. Therefore, we created simple study resources focusing on getting high grades in the simplest way possible. All our notes and resources are focused specifically on giving students the best chances of achieving a first class from our experience. Our notes are full of exam tips that gives you insider information about how to get a high grade. That is the unique point of our resources, and this is how we distinguish ourselves from traditional revision books. If our resources are not enough, you are highly recommended to have a look at our tutoring services, which is an additional service that we provide for students who need more personalized support. You can book time with a tutor here at this link, and you will be able to have one-to-one meeting with a tutor on Zoom, where you will be able to discuss anything you may be struggling with. It can be anything general, how to get a high grade, how to write problem and essay questions, or even specific, if you have a specific question you need to help with, to do some legal research or get some insights about how to plan the assignment or how to do legal research. Anything you may be struggling with, we will be able to help you on tutoring sessions. We have already helped thousands of law students to get high grades. Our regular students who study with our resources, as well as occasionally tutoring, they are usually at the best chances of getting a first class. We would like you to be our next student to get high grades. Please join Simple Studying now. And also please join our WhatsApp groups, where you can ask our community any questions that you may have. Thank you.